Welcome to the Bar Exam Toolbox podcast. Today we are walking through a California criminal law and procedure question. Your Bar Exam Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully move on. And hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox Podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we'd love to hear from you. And with that, let's get started. Welcome back. Today we are walking through a criminal law and procedure question. This is another in our series of podcasts talking about how to approach questions on the California bar exam. And don't forget to subscribe to our podcast so you won't miss any upcoming essay discussions. When we're working through the many essays given to us on bar exam day, we won't be told directly what substantive topic or topics are tested in the essay. But by looking at keywords at the beginning of the fact pattern and in the essay question prompts, we can quickly hone in on the overarching substantive topic that is being tested. By doing this, we focus our attention and memory on only those rules that will be relevant to us for this particular essay. Here, we immediately see the words kill, warrant, and arrest in the facts, and Fourth Amendment in the question, telling us that we're dealing with a criminal law and procedure question. But before we go any further through today's question, we will need to do a quick review of the law you will want to know for this question, which includes both criminal law and criminal procedure. The Fourth Amendment, which is incorporated against the states through the Due Process Clause of the 14th Amendment, prohibits unreasonable searches and seizures. The exclusionary rule provides that the product of unreasonable searches and seizures in violation of the Fourth Amendment and coerced confessions in violation of the Fifth Amendment are to be excluded from any subsequent trial. The fruit of the Poisonous Tree Doctrine states that all products and evidence derived from police illegality are excluded and barred from introduction at trial. The fruit of the Poisonous Tree Doctrine can be overcome if 1. There is an independent source for the evidence or contraband. 2. There was an intervening act of free will on the part of the defendant. Or 3. It was inevitable that the police would have obtained that evidence. For a search by a state actor to be valid, it must be conducted pursuant to a valid warrant issued by a neutral magistrate or an exception to the warrant requirement. A warrant, whether for search or arrest, can only be issued if probable cause exists. Probable cause exists when there is a fair probability that the search place will contain contraband or other evidence of crime, and that the arrested person has in fact committed the crime of which they are suspected. Probable cause is determined by examining the totality of the circumstances. A tip from a reliable informant can establish probable cause. One exception to the warrant requirement is the good faith exception, or when an officer relied on an invalid arrest warrant in good faith, meaning that the officer did not know that the warrant was lacking in probable cause. This exception is not available when any of the following is true. 1. The warrant on its face is so lacking in probable cause that no reasonable officer would rely on it. 2. The warrant on its face is so lacking in particularity that no reasonable officer would rely on it. 3. The officer misled the magistrate in issuing the warrant. Or 4. The magistrate was so biased against the object of the warrant that he could be said to have given up all neutrality. Police can typically perform a warrantless arrest in a public place whenever they have probable cause to believe that the person has just committed a crime. A person is guilty of solicitation where they urge, request, or pay another person to commit a substantive offense. Murder is the intentional killing of another person with malice and aforethought. Pursuant to a valid arrest, police can search the arrestee, including the arrestee's person, and anything within the person's wingspan. Under the Self-Incrimination Clause of the Fifth Amendment and the Miranda case, which implements it, incorporated against the states by the Due Process Clause of the 14th Amendment, Police must warn people of their rights to remain silent and to an attorney before commencing a custodial interrogation. An interaction is, quote, custodial anytime a reasonable person would not feel free to leave. The interaction is an interrogation anytime the police act in a way that they know or should know is likely to elicit an incriminating response. The warning must convey that 1. The person has the right to remain silent. 2. Anything they say can be used against them at trial. 3. They have a right to speak to an attorney. And 4. That if they cannot afford an attorney, one will be provided. Violations of a suspect's Miranda rights improve grounds to suppress any incriminating statements, though they will not necessarily lead to the suppression of the investigatory fruit of such statements. The defense of entrapment requires a defendant to show 1. Inducement, and 2. A lack of predisposition. Inducement occurs when a criminal design originates with the police. A lack of predisposition occurs when the defendant was not otherwise intending to commit the crime. Okay, now let's move on to reading the bar exam question. This is a question from the February 2017 bar exam. We will link to a webpage where you can find this question in the show notes. Here we go. Ivan, an informant who had often proven unreliable, told Alan, a detective, that Debbie had offered Ivan $2,000 to find a hitman to kill her husband, Carl. On the basis of that information, Alan obtained a warrant for Debbie's arrest. In the affidavit in support of the warrant, Alan described Ivan as a reliable informant, even though Alan knew that Ivan was unreliable. Alan gave the arrest warrant to Bob, an undercover police officer, and told Bob to contact Debbie and pretend to be a hitman. Bob called Debbie, told her he was a friend of Ivan and could do the killing, and arranged to meet her at a neighborhood bar. When the two met, the following conversation ensued. Bob: I understand you're looking for someone to kill your husband. Debbie: I was, but I now think it's too risky. I've changed my mind. Bob: That's silly. It's not risky at all. I'll do it for $5,000 and you can set up an airtight alibi. Debbie: That's not a bad price. Let me think about it. Bob: It's now or never. Debbie: I'll tell you what. I'll give you a $200 down payment, but I want to think some more about it. I'm still not sure about it. When Debbie handed Bob the $200 and got up to leave, Bob identified himself as a police officer and arrested her. He handcuffed and searched her, finding a clear vial containing a white, powdery substance in her front pocket. Bob stated, well, what have we got here? And Debbie replied, It's cocaine. I guess I'm in real trouble now. Debbie has been charged with solicitation of murder and possession of cocaine. Number 1. How should the trial court rule on the following motions? A. To suppress the cocaine under the Fourth Amendment? Discuss. B. To suppress Debbie's post-arrest statement under Miranda? Discuss. 2. Is Debbie likely to prevail on a defense of entrapment in trial? Discuss. The first thing you should do is mark up your exam paper to assess what is legally significant about each fact in the fact pattern. So let's run through them. Ivan says that Debbie offered him $2,000 to kill her husband. This fact shows that before any of the officers were involved, Debbie had put in motion a plan to kill her husband. Ivan is described as an informant who had often proven unreliable, and Alan knew that Ivan was reliable. This fact demonstrates that Alan, the detective, knew that the information he was getting was unreliable and that it shouldn't form the basis for probable cause for the arrest warrant. In his affidavit, Alan described Ivan, the informant, as reliable. This fact shows Alan did not have reasonable, trustworthy information to execute a valid search warrant. However, because Alan described Ivan as reliable in his affidavit, an officer executing the arrest warrant wouldn't have realized the warrant lacked probable cause. Next, Alan gave the arrest warrant to Bob, an undercover police officer, and told Bob to contact Debbie and pretend to be a hitman. This fact shows that Bob, the officer that made the arrest, was relying on a warrant and he had no reason to suspect it was invalid. Bob called Debbie, told her he was a friend of Ivan's and could do the killing, and arranged to meet her at a neighborhood bar. Now, Debbie independently went to the bar to discuss the proposition of killing her husband. When the two met, the following conversation ensued. First, Bob said, "I understand you're looking for someone to kill your husband." And Debbie said, "I was, but now I think it's too risky. I've changed my mind." Now, Debbie admits that she initially wanted to kill her husband, but now she isn't as sure as she was before. Her concern, however, is just that it's risky, and she's concerned about getting caught. It also illustrates that it was originally Debbie's plan. No one coerced her into hiring a hitman. Now, Bob continues, "That's silly. It's not risky at all. I'll do it for $5,000 and you can set up its airtight alibi." Now, even though Debbie is unsure, Bob tries to convince Debbie to go through with it by offering a price and an alibi. Debbie replies, "That's not a bad price. Let me think about it." And Bob says, "It's now or never." Now here, Bob again pushes Debbie to move forward despite her hesitation, providing another fact showing the government's involvement in inducing her to commit the crime. Now Debbie continues, I'll tell you what, I'll give you a $200 down payment, but I want to think some more about it. I'm still not sure about it." So Debbie is willing to give a down payment for him to go through with the killing of her husband, but she expresses her hesitancy again. But her hesitancy seems to deal with her concern about getting caught. When Debbie handed Bob the $200 and got up to leave, Bob identified himself as a police officer and arrested her. He handcuffed and searched her, finding a clear vial containing a white powdery substance in her front pocket. Now, this fact shows that Bob searched Debbie's person immediately after arresting her, and we know that a search of an arrestee's person and anything within that person's wingspan is okay. We also know that Debbie is now handcuffed and would most certainly not feel free to leave or run away. So then Bob stated, well, what have we got here? Before reading Debbie any of her rights and after handcuffing her, Bob directly asked Debbie a question that is likely to lead to an incriminating response about the white powder he just found. Debbie replied, "It's cocaine. I guess I'm in real trouble now." Debbie told Bob what was in her pocket before being read her Miranda rights and after she'd been handcuffed. Okay, so now we've gone through all the facts. Let's look at how to actually answer this question. You would start any outline or answer by breaking up your paper into at least one section for each of the three questions. We have 1A, 1B, and number 2. Ideally, you would also segment your outline even further into sections 1 and 2 as there are multiple issues. So make sure your outline would look like this. Number 1, how should the trial court rule on the following motions? A, to suppress the cocaine under the Fourth Amendment, and B, to suppress Debbie's post-arrest statement under Miranda. Then a number 2, is Debbie likely to prevail in a defense of entrapment in trial? So let's look at each segment separately. Question 1A, how should the trial court rule on Debbie's motion to suppress the cocaine? The first sub-issue is whether the arrest is consistent with the Fourth Amendment. So you might remember our rule. The Fourth Amendment provides that no warrant, whether for search or arrest, be issued unless there is probable cause. Furthermore, probable cause exists where the facts and circumstances within the officer's knowledge and of which they had reasonable, trustworthy information are sufficient in themselves to warrant a person of reasonable caution in the belief that a crime has been or is being committed. Additionally, knowledge obtained by an informant is examined under a totality of the circumstances test. This means that the information may be sufficient to establish probable cause even if the reliability and credibility of the informer or his basis for knowledge aren't established. So here, Allen must demonstrate that there was a valid basis for obtaining the arrest warrant. This will be problematic because Allen received the information from his unreliable informant, Ivan. Also, Allen intentionally mischaracterized Ivan in the warrant by claiming he was a reliable informant. Although there are not facts to show that Ivan's claim was invalid, there may be some deference given to the officer since this case involves the solicitation of murder. These facts are not enough to overcome the previous arguments against the search warrant. The arrest warrant will likely be deemed invalid for lack of probable cause. The second sub-issue on the first question in this essay involves the fruit from the Poisonous Tree Doctrine, or evidence obtained in violation of the Fourth, Fifth, or Sixth Amendments. The exclusionary rule provides that the product of unreasonable searches and seizures in violation of the Fourth Amendment and coerced confessions in violations of the Fifth Amendment is to be excluded from any subsequent trial. The fruit of the Poisonous Tree Doctrine states that all products and evidence derived from police illegality are excluded and barred from introduction at trial. The fruit of the Poisonous Tree Doctrine can be overcome if 1. There is an independent source for the evidence or contraband, 2. There was an intervening act of free will on the part of the defendant, or 3. It was inevitable that the police would have obtained that evidence. Now here, Bob executed the search warrant, not Alan. However, Bob is not excused under this rule by having a different officer execute the warrant. Since the evidence was obtained illegally, it will be barred unless an exception applies. Here, there is no independent source for the evidence, so that exception does not apply. There is no intervening act of free will on the part of the defendant because B searched D subject to an arrest. Also, there are no facts to establish it would be inevitable that the police would obtain the evidence. So none of those exceptions apply here either. Therefore, the cocaine will likely be excluded since it was only discovered through a violation of the defendant's Fourth Amendment rights. The second sub-issue here is whether there was a valid search and seizure. Let's remember our rule. The Fourth Amendment provides against unreasonable search and seizures. The Fourth Amendment protections attach when there is government conduct and a reasonable expectation of privacy. Additionally, the government must possess a valid search warrant, or there must be an exception to the evidence to be admissible. A search incident to arrest is an exception to the warrant requirement. An officer has an automatic right to search an arrestee's person and things within the reach of the defendant at the time of the arrest. If the arrest was without probable cause, the search incident to arrest cannot be justified on the incident to arrest exception to the requirement of a search warrant, and the evidence must be suppressed unless some other exception to the warrant requirement justifies it. This is a relatively simple rule with several layers and elements, so let's break this down into small subsections. First, was there government conduct? Here, yes, clearly B was an undercover officer acting on behalf of the government, so this element is met. Second, did Debbie have a reasonable expectation of privacy? Yes, Debbie had a reasonable expectation of privacy here because the cocaine was found in her pocket. Third, was there a valid search warrant? Well, here, no. As discussed before, we only have an arrest warrant, and that arrest warrant was invalid for lack of probable cause. So then do any exceptions apply? Well, the plain view doctrine would not apply because the cocaine was not in plain view. This is not a situation of stop and frisk. This exception applies when there is a reasonable suspicion of criminal acts supported by articulable facts. Officers are allowed to frisk if there is reasonable suspicion that the subject is armed and dangerous, but is limited to finding weapons. Now, it's possible that this exception may apply considering the conversation between B and D, but there's no indication that Debbie herself was armed and dangerous, and cocaine is not a weapon. Lastly, one exception to the warrant requirement is the good faith exception, or when an officer relied on an invalid arrest warrant in good faith, meaning the officer did not know that the warrant was lacking in probable cause. This exception is not available when any of the following is true. Number 1, the warrant on its face is so lacking in probable cause that no reasonable officer would rely on it. 2, the warrant on its face is so lacking in particularity that no reasonable officer would rely on it. 3, the officer misled the magistrate in issuing the warrant. Or 4, the magistrate was so biased against the object of the warrant that he could be said to have given up all neutrality. Now here, Bob appears to rely on the warrant in good faith. There are no facts to suggest he knows the warrant lacks probable cause. However, it is clear that A lied in the warrant application when he indicated Ivan had reliable information. This lie invalidates the good faith exception because the officer misled the magistrate in issuing the warrant. Thus, the good faith exception would also not apply. So in conclusion, there are no exceptions that would excuse Fourth Amendment violations present in this fact pattern, and the evidence will not be admissible. Wow, that was a lot for question 1A. So let's move on to question 1B. How should the trial court rule on Debbie's post-arrest statement under Miranda? Well, here the main issue is whether Debbie's Miranda rights were violated. The Fifth Amendment requires Miranda warnings to be given to anyone subject to a custodial interrogation. Note that with undercover agents, if the defendant talks to an undercover agent without knowing she is talking to law enforcement, no custodial interrogation has taken place. However, we can quickly raise and dismiss this exception because the statement occurred after B indicated that he was an officer. He'd arrested her. So therefore, Debbie knew that B was a law enforcement agent when the statement was made, and the undercover agent exception does not apply. And we know there were no Miranda warnings given. So if Debbie can establish that a custodial interrogation took place, she's going to succeed in suppressing the evidence. Now, this section should be divided into two sub-issues. The first discussing whether the suspect was in custody, and the second discussing whether an interrogation took place. So let's kick it off with custody. Our rule here is whether or not a suspect is in custody is determined by an objective test. An interaction is custodial anytime a reasonable person would not feel free to leave. Here, there is little doubt that Debbie would be considered in custody under this rule. First, Debbie is in handcuffs, and no reasonable person in handcuffs would believe they are free to leave. Therefore, this element is met. Now we must analyze whether B's statement constitutes an interrogation. Our rule here is that statements that are likely to elicit an incriminating response qualify as an interrogation. However, voluntary statements are admissible in violation of Miranda. The state will argue that Debbie made a voluntary statement that was not in response to Bob's question. However, since the statement was made right after Bob's, it will likely be considered an answer to Bob's question. It was not a spontaneous voluntary statement. Now, additionally, B's question was likely to elicit an incriminating response because he already had reason to suspect the item was contraband because it was a small vial of white powder. Therefore, under these circumstances, the question, "What have we got here?" was calculated to obtain an incriminating response, and an interrogation took place. So a custodial interrogation took place without proper Miranda warnings, and Debbie's statement will be inadmissible. Now, finally, we get to question 2, whether Debbie is likely to prevail on a defense of entrapment in trial. Before tackling the defense of entrapment, we must first establish the underlying crime Debbie is charged with. Our rule here is about solicitation. It occurs when an individual intentionally invites, requests, or commands another person to commit a crime. If the person agrees, it's a conspiracy. If the person commits the offense, the solicitation charge will merge with the completed offense. This is a specific intent crime, and the underlying crime here would be murder, the intentional killing of another person with malice and aforethought. Debbie offered $2,000 to Ivan to find him a hitman to murder her husband, and B posed as someone agreeing to be the hitman. On the surface, there appears to be a request from Debbie for another person to commit the crime of murder. However, there is still a question of whether Debbie possessed the specific intent necessary, or whether she was baited into an agreement by the undercover officer. If Debbie can establish an entrapment defense, this will demonstrate that she did not have the specific intent necessary to prove a solicitation claim. So we must look at the rule for entrapment. Entrapment is a very narrow defense, and merely providing opportunity for a predisposed person to commit a crime is not entrapment. The government may not originate a criminal design, implant in an innocent person's mind the disposition to commit a criminal act, and then induce the crime's commission. Where the government has induced an individual to break the law and the defense of entrapment is an issue, the prosecution must prove beyond a reasonable doubt that the defendant was disposed to commit the criminal act prior to first being approached by government agents. Debbie will succeed in this defense if she can prove the police originated the criminal design, but she will fail if the scheme was Debbie's original idea. So Ivan tells Alan that Debbie had offered him $2,000 to find a hitman. According to Ivan, Debbie had to come up with this plan herself. However, we also know Ivan is kind of unreliable, and the evidence must establish it was Debbie's original idea beyond a reasonable doubt. So here, it seems like there's at least some doubt to the truthfulness of Ivan's claim. Now, Bob, the undercover officer, asked Debbie whether she was looking for someone to kill her husband, and Debbie tells him that I was, but now I think it's too risky and I've changed my mind. Bob continues to push her to commit to the plan as he increases the asking price to $5,000 from $2,000. There is a strong argument that this is entrapment, since now B is trying to push Debbie into a new plan that costs more. It also shows Debbie was not predisposed to commit the act, so she decided against committing the criminal act, and she had to be enticed by Bob. Alternatively, Debbie did admit that she planned to hire a hitman. That seems to negate an argument for entrapment since she was arguably predisposed to this act since she previously had to plan for it. Additionally, Debbie puts down a down payment while indicating she still wants to think about it. This fact can be used to argue both sides. The deposit is an indication that Debbie is willing to agree to the crime, but the fact that she asked for time to think about it also indicates that she is not yet committed to it. Although the facts indicate that Debbie was likely predisposed to commit this crime, the circumstances are ambiguous enough that you could earn full credit for arguing either outcome here. What is important is that you use the proper facts supporting arguments you think are the most persuasive. Now, in conclusion, you could find Debbie either likely or not likely to have a valid defense of entrapment, depending on how you argued. All right, so that's it. Remember, the key to succeeding on questions that involve complex rules and subrules, especially including criminal procedure and constitutional law questions, is to outline effectively before you write. It is critical to hone in on the overarching rules that apply and then note all of the sub-rules and exceptions as well. That way, you will have a solid roadmap as you start drafting, and the bar exam graders will have an easy time assigning you some well-deserved points. And with that, we're out of time. I want to take a second to remind you to check out our blog at barexamtoolbox.com, which is full of helpful tips to help you prepare and stay sane as you study for the bar exam. You can also find information on our website about our courses, tools, and one-on-one tutoring programs to support you as you study for the UBE or California bar exam. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it. And be sure to subscribe so you don't miss anything. If you're still in law school, you might also like to check out our popular Law School Toolbox podcast as well. If you have any questions or comments, please don't hesitate to reach out to Lee or Alison at lee@barexamtoolbox.com or alison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.